Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Welcome to our firm's virtual First Friday free call-in. Thanks so much for being here today. First, I want to start out by wishing everybody a happy Halloween. I don't know if people in your neighborhoods are now starting to decorate, but it's a fun time of the year for everybody. So hopefully you guys are doing some community building in your community right now. I know a lot of our clients have done that over the years, and it's been a really great community building thing to do. Okay, let's get started with our questions today. We have a lot of questions. So I know that some of you are joining us here on Zoom, and some of you are joining us here on Facebook Live. So welcome to all of you here today. My name is Beth Mulcahy, and I'm the founder and senior partner of the Mulcahy Law Firm in Phoenix, Arizona. I've worked with, as their legal counsel, HOAs and condominiums throughout the state of Arizona for over 25 years. It's gone by really fast, actually. I can't believe I have a 25 and 5 years practicing law now. My firm currently represents over 1,000 community associations throughout the state of Arizona. And some of you may know me from the virtual classes that I teach on a monthly basis. So you have a partnership that we do with the neighborhood services departments from all around the valley and in Phoenix, Arizona, and all the surrounding cities. And also we do our First Fridays, like today, the first Friday of every month. So welcome to our firm's virtual First Friday free call-in. First Fridays are a great time for board members, managers, and homeowners to have your questions on Arizona law regarding HOAs and condos answered for free. Here's how First Fridays will work today. If you haven't already done so, please submit your First Friday questions in the Q&A box on Zoom or in the comments section on Facebook Live as soon as possible. And I'm going to answer all questions between now and hopefully 10 o'clock a.m. But I promise I won't sign off until I answer every question this morning. Just a quick and friendly reminder, because we have so many questions that come in on the First Fridays, this First Friday opportunity is limited to one question per association. And if you plan on submitting a question live during this session, please include the name of your HOA and condo and your current role when you submit your question. Don't worry, we don't use any names of HOAs or any names of people who are submitting the questions. It's just helpful for me to know whether a board member, manager, or a homeowner is asking the question. If you have more questions than the one questions today, don't forget to tune in to our upcoming virtual classes, which we'll be talking about in a few minutes. You also can find more information on that on our website at mulcahylawfirm.com. And that has a full listing of all of our upcoming seminars. First, talk a little bit about the 2022 legislative update. All of the new laws, all 5 of the new laws that were passed in the 2022 legislature have now become law. Those all went into effect on September 24th. And our firm is going to be sharing our new cheat sheet, which we issued regarding the 5 new laws pertaining to HOAs and condos. They're important for you to take a look at this handout. And we're going to be sharing it with you on Zoom and Facebook Live. And it's a really good summary of the new laws. Just very briefly, there's a law that says planned communities have to allow artificial turf under certain conditions. The owner wants to put artificial turf on their property. There's also a law that talks about first responder flags now being protected, and associations cannot prohibit those. Political signs for association matters or association issues can now be protected, and owners are allowed to place those on their property. That's kind of an interesting development. So political signs for board elections in your community or voting for or against a special assessment, owners can now put those signs on their property. And owners have a right to peacefully assemble on your common areas to discuss association issues. That's kind of a newer law that just passed in September. And lastly, some restrictions by cities and towns to crack down on short-term rentals and to make it more difficult to have bad renters and short-term rentals in cities and towns and counties across the state of Arizona. So lots of great information this year in the legislature, and we hope you'll take a deep dive into our legislative update cheat sheet, which we just shared with you. Okay, also, don't forget to tune in to our firm's virtual HOA Academy class number 10 on October 18th, it's Tuesday, 11 a.m., where we're going to discuss and answer questions regarding enforcement of your association's governing documents and also how to collect delinquent assessments. We're starting to see a big uptick in the number of owners that aren't paying assessments with the increased inflation rates and other things going on in our economy. So this is definitely a class you won't want to miss. We're going to give you the ABCs of how to enforce matters in your association for owners who are violating the association's documents and what legal remedies you have. And then we're also going to talk about how to get owners to pay assessments in a timely manner and how to collect delinquent assessments from owners who are delinquent in the payment of assessments, fines, and other amounts that are owed to the association. So that'll be a great class. Hope you'll tune in on October 18th at 11 a.m. Our office is going to be sharing our upcoming events with a link to you now on Facebook Live and also on Zoom. Okay, let's get right into the questions here today. We have a lot of questions. We have 44 questions this morning, which is awesome. And I think I'm going to get a count pretty soon of how many people have joined us this morning. So I'll be sharing that with you shortly as well. Our first question talks about our CC&Rs were written in 1998 and expressly forbid renting a guest house. Do you know if recent Arizona law supersedes our 1998 CC&Rs? An excerpt from our CC&Rs is rental of any guest house is prohibited. The occupancy thereof shall be limited to members of the owner's family, guests, and servants. Okay, so I think that the CC&Rs that were written in 1998 containing the provision are still valid. I'm not aware of any Arizona law that would supersede that provision in your CC&Rs. Okay, I just got a little update. We've got about 45 attendees on Zoom and more of you joining us on Facebook Live this morning. So great turnout this morning for our First Fridays. Our next question is from a community manager. Our annual meeting notice states credit in the amount of $40 will be applied to the board member's account for each regularly scheduled board meeting attended. Our monthly dues are $40 a month. This is an offer for HOA board members to skip all yearly dues if all 12 monthly meetings are attended in a year. Is this legal? A couple of things that I would say. First, at first glance would be, this is not something that I would recommend. This is very unusual. Most associations, or I think 99% of associations, do not pay board members to serve as board. There is a provision in the Nonprofit Corporation Act that says that if the bylaws allow compensation, that then you can compensate board members for their participation being on the board. But again, it's pretty unusual. We don't see that very often. So I don't know. I know your annual meeting notice says this, but I don't know if it's in your association's bylaws that this is something that's a compensation is allowed for serving on the board. But without that, you cannot pay the board members just for attending board meetings or participating as a board member. Okay, next question. Question 3, a board member. Our HOA CC&Rs state that there can be no rentals for less than 30 days. Is this considered short-term under the law? And how does the new Senate bill affect owners who want to rent their condos? Okay, so if your CC&Rs say no rentals for less than 30 days, you have a short-term rental prohibition. So owners cannot rent their property for less than 30 days pursuant to your CC&Rs, and that's a binding contract. So it is considered short-term in my opinion, under the law in Arizona. How is the new bill pertaining to responsibilities for landlords and owners who want to rent their condos? How is that going to affect them? How's it going to impact the association? Is also a good kind of follow-up question on that. Owners who are renting their property as a short-term rental in Arizona, starting September 24th, have some additional responsibilities for notifying their city, town, or county of the fact that they're renting the property. And so what I would recommend to owners is to reach out to the city that your property is located in or town that your property is located in and find out what sort of restrictions or ordinances they have passed in response to the new Senate bill that passed and became the law on September 24th. There may be a requirement for you to get a permit. There may be a requirement for you to get insurance, additional insurance, if you're not using like a national or or rental agency that has their own insurance that passes through to you. May have to give the names of the adults that are going to be, the emergency contact information for the property and the phone number, the way that a person can be reached in the event that there's an emergency at the property. So there's going to be additional burdens on the owner landlord to provide information to cities, towns, municipalities, county. So how this impacts the association is if there's a problem on the short-term rental and your city, town, or municipality has ordinances that require permit or require emergency contact information, you will be able to make complaints to the city, town, or municipality regarding the short-term rental. And the city, town, or municipality hopefully has some teeth in their ordinances that will require to comply or going to get big fines assessed against them by the city, town, or municipality. Okay, next question from a new board member. Can harassment be upheld in court simply by someone claiming they feel harassed by receiving violation notices? Or do specific actions or words need to have occurred for it to be upheld in court? When homeowners use the word harassment with our property manager after they receive notice for a documented violation, she retreats and stops sending notices or following up with them regarding their non-compliance to our governing documents and processes. Okay, we have a great cheat sheet on this topic. It's called Dealing with Difficult People and Harassment, and we're going to be sharing that with you here shortly. And it defines specifically what the meaning of harassment is under Arizona law. And it talks about, what the standard is, what the requirements are in order to get an injunction prohibiting harassment against another owner or against another person for harassing you. Sending a letter regarding a documented violation to an owner is not harassment under Arizona law. That is enforcing our contractual responsibilities as board members, and the manager has a responsibility to do that. So if an owner is claiming that they're being harassed just because they receive a violation notice, in my opinion, that's not considered harassment. Harassment would be somebody making a threat of physical harm or actually physically harming another person. So be like pushing them, shoving them, or, leaving a voicemail saying, I will take care of you, or you'll be sorry. Those are the type of things that would rise to the level of harassment. And so I think what the board needs to do is have a discussion with the management company, maybe even this property manager supervisor, to talk about why the manager has stopped sending violation notices. And maybe if the manager feels uncomfortable about dealing with this particular owner, maybe this matter needs to be escalated to the association's attorney to handle the violation. Okay, question number 5. We have a manager who's responding to us. 3 positions are up for re-election. 3 people on the ballot. First 2 candidates get votes, but the third candidate receives no votes. Do they still get elected since there are 3 positions up for re-election, even though no ballot voted for the third candidate? Okay, that's a really odd fact pattern, because you would think that the third person that got no votes, why didn't they vote for themselves? Right? All they needed was 1 vote to be elected. So if I were looking at this issue, what I would do is I double check the bylaws. And I don't have your bylaws in front of me, but in order to be elected, you have to get at least 1 vote to serve on the board. More likely than not, this person did not get elected, third person that did not get any votes. The board likely has a provision in their bylaws that gives the board the authority to appoint somebody and to be able to serve in an open board position. So an option that the board could do would be after the annual meeting to appoint this third candidate who didn't receive any votes to the board, although there's no obligation to appoint that candidate. And maybe there might be a reason not to appoint that candidate if they didn't get any votes. So something to think about. But those are the different options here. Okay, next question from a board member and one of my favorite clients. So great to see her today. We recently had a homeowner that decided that he did not like a tree that was next to his property. This tree was in an HOA common area, so he proceeded to remove the tree. Uh-oh, that's bad. Can we as an HOA charge him for the replacement or fine him for the removal? And if so, how much is allowed? Okay, this is an interesting question. The trees on the common area, it's obviously the association's property. Most associations documents, CC&Rs, have a provision in there that says that if an owner causes damage to another owner's property or to the common areas, that the association can charge the owner for that damage. So you might have a provision like that in your documents that would allow you to charge the cost to replace the tree. Of course, you're going to have evidence that this person did it, because they may, unless they've admitted to it, they may say they didn't do it. Maybe you have a picture of a tree removal company. Maybe your pictures of the owner that removed it doing it. That obviously would be enough evidence if somebody missed to it. You also could fine the owner for a violation, and that amount that would be pursuant to the CC&Rs for causing damage to the common areas. Again, I would limit the fine to the cost to replace a tree of similar size and similar type in that same area. Now, you might want to really think about talking with this owner about, okay, why did you want this tree removed? Maybe the tree was dumping a bunch of leaves in their pool. And so when you put the tree back in, you may want to really think about the placement so that it doesn't cause that same issue to arise again in the future. Or maybe the tree is causing the wall to lift and then the owner doesn't like it. So try to, obviously this is bad behavior. I don't like to hear this owner did this, but try to make this a win by talking with the owner, get the owner to reimburse the association costs. Maybe you could put it a little further away, but still in the common areas. If the owner just completely denies that they did it, you will need to get legal counsel involved, and I can help you with contacting the owner and sending a letter on that. Okay, next question, number 7, from a board member. 6 years ago, we added 2 pickleball courts to our recreational area, which is close to some homes. Now, a homeowner who was a resident when the courts was built is threatening to sue if we don't shut the pickleball courts down or move them due to noise. Can this owner arbitrarily sue after 6 years? He isn't interested in noise abatement. He wants them gone, and we cannot come up with a compromise. Okay, noise issues are always a complicated and difficult issue. A couple questions that I would want to know are the other homes that you mentioned here. Are they also complaining about the noise? Do you have set hours when pickleball can be played? Can it be played any time of night, like even under the lights, 11 o'clock at night? That might be considered unreasonable. So hopefully there aren't other complaints. I don't know if I guess the homeowner was a resident and apparently in that lot next to the pickleball courts, and that owner may have objected at the time, maybe didn't object. Can they object now or arbitrarily sue after 6 years? I don't think that they can sue to say that the decision by the board 6 years ago was a bad decision, because the statute of limitations likely has run on that. But they could potentially sue for creating a nuisance if there is a big noise issue. So if I were looking at this issue, what I would do is I would look at, have there been other complaints from the other neighbors who are close to the pickleball courts? Do you have reasonable times where pickleball can be played? I know where I live, we have 2 pickleball courts, and you cannot start playing pickleball until after 9 a.m. And we don't have lights on the pickleball courts because we don't want people playing pickleball after dusk. If the noise issue is becoming, other people are complaining about it, you may want to bring in a sound expert or a noise expert to measure the decibel level to see if it's outside the normal range. We've done this in other pickleball cases and found that it is not outside the normal decibel range. And that would be possibly a good defense if this owner continues to threaten you. One thing I want to mention is you may want to think about notifying your insurance carrier that this owner may possibly sue you in the future. Probably have a provision in your insurance policy that requires notice anytime an owner threatens to sue you. This might be one that you want to escalate right to your legal counsel for your association. Okay, next question, number 8, is from a homeowner. Over our 1998 CC&Rs explicitly state rental of any guest house is prohibited. The occupancy therein shall be limited to members, owners, families, guests, or servants. Our question is, does ARS 9-500 2.39 override this language or do the CCNRs prevail? I don't have that ERS section right in front of me, so I'm going to ask my office to just add it to the script, and then I'll come back to this question at the end. Okay, so next question is for a board member. Number 9, our HOA restricts rentals to a minimum of 30 consecutive days. My understanding of Senate Bill 1168 is that it's limited to rentals under 30 consecutive days. Is this correct? That Senate Bill 1168 is not applicable to our HOA. I don't have your association CCNRs, so it's hard for me to understand where exactly you have that minimum rental period. When we look at Senate Bill 1168, it's going to be restrictions that the city, town, or municipality places on the landlord owner. And so we'll want to see how the city, town, or municipality structures ordinances. How do they define short-term rentals? I'm in full agreement that short-term rental is typically defined as less than 30 days or minimum 30, less than 30 days. And so it's possible, based upon how they word their ordinance, that it could apply to just a short-term rental that is less than 30 days, or they could define short-term rental as nightly. It just depends on how it's defined by each ordinance. Okay, next question, number 10. Let's see, would it be legal for the HOA board, and this is from a member of the community, to approve a transfer fee on home sales in an association and direct it to the golf club organization, one that's a 501c4, and that says golf is a 501c7 corp. The statute regarding transfer fees or capital improvement fees, which is ARS 33-442, mentions the fees touch and concern the land. Fee charge may not be payable to a third party or a declarant unless that third party is specifically authorized in the CCNRs to manage the plan of development. And any such fee or charge that is imposed by a document that is payable to a nonprofit for the sole purpose of supporting rec activities in the association. So your question is, can our board use the transfer fee or the capital improvement fee to direct it to the golf club organization? So I don't know if this golf club is like part of your community, meaning is it an amenity for your owners, or is it like it's a separate entity, but maybe it's exclusive use for your owners? And I don't know what your CCNRs state on this. Your CCNRs authorize you to charge this fee, and then does it comply with 33-442? And does it authorize you to move this fee to a third party for supporting an activity in the association? So lots of questions that I don't have answers to in response to your question. But generally speaking, as long as the association complies with this 33-442 Arizona revised statute, and it specifically lays out how the fee is going to be used, it should be fine, but I'd have to know more information. Okay, question 11 from a board member. The statutes state that before going into executive session, the board must state what subjects are to be addressed. If the board takes up a subject improperly, i.e. not one of the 5 subjects allowed, can I talk with homeowners about it? Moreover, I've been told that any action taken in such improper executive session is void. Is that correct? Okay, a couple things. So we're talking about executive sessions. And what I would recommend to all associations who are doing their notice of executive sessions is to list in the notice that you will be talking about one or all 5 of the sections in the Arizona revised statutes that you're allowed to talk about in executive session. That way, when you go into the meeting, you can discuss any of the 5 areas. If anything should come up regarding any of those 5 areas, that's just a safe thing to do. Good best practices to implement. Now, if your association, in your case, the question is, okay, our association didn't put that in the notice. They did not say that we will be talking about one or all 5 of the exceptions to go into executive session where it's just the board. They maybe just put one of them down. But during that meeting, it's limited to the discussion of just that one topic because that's all you notified your owners of. Does that mean that as a board member, you can talk, and let's say your board goes forward and you talk about another topic that you didn't properly notice? And it's an executive session topic, but you didn't tell the owners you were going to talk about it in the notice. can you, as a board member, now talk about the homeowners with it because it wasn't in the notice? No. Okay. Anytime that you're hearing information in an executive session and it's an executive session topic, you should not be giving that information to anybody, your spouse, third parties, other homeowners. That information is executive session. Now, I don't disagree with you that it was improper for your board to talk about a topic during executive session that wasn't notified to the homeowners. You didn't notify the homeowners that you're going to talk about it. That's a mistake, but it doesn't equal that you can go tell all the homeowners about it. But the next question is, if we take an action in an improper executive session, is that action void? So, that's kind of an open-ended question. But if the example is, okay, we went into executive session to get advice from our attorney regarding somebody who's going to sue us regarding the pool not being warm enough. And while we noticed it, or we're going to be getting legal advice from our attorney pursuant to the number 1 on the executive sessions statute. And while we were there, we crossed over and talked about an owner who was delinquent in the payment of assessments, separate owner. And we decided that we were going to have the attorney make a settlement offer to that owner who's delinquent. Does that make that action improper? No. From a practical standpoint, no. Does it mean that you didn't properly notice that you were going to talk about that? Yes. It's just the type of thing that if a board came to me on this after the fact, I would say just do it correctly in the future. But I don't think it voids that action in the example I just gave you. Okay, next question from a resident. Number 12, if a board member pushes or shoves a homeowner, is there a law or mechanism that states that the board member must resign immediately? I'm very sorry to hear that that's happened. That is not appropriate behavior by a board member or a homeowner at a board meeting. To give you a short answer, does that mean the board member must resign immediately? No. Does it mean that the board member acted improperly and was out of line? Yes. I think that there should be an apology. I think that the association's legal counsel should be involved in this matter. An apology from board member to the homeowner. I think we should notify the insurance carrier that there may be potential litigation on this. I think there should be a hard look at whether this board member should resign on their own volition or the behavior, and probably the attorney for the association can assist with talking with this particular board member about the board member's behavior. If the board member does not resign, this might be something where petition is circulated to remove that board member from office pursuant to state law. But this is not appropriate behavior. And if the owner was the recipient of the push or the shove, they likely will have the right and ability to go get an injunction prohibiting harassment in justice court against the board member. Okay, next question from a board member. Our HOA CC&Rs are 40 years old. Is there a publication that is available that addresses changes in the revised statutes that would help clarify our board's understanding of our governing documents? So our cheat sheets would be a very good group of publications that could help you better understand changes in the law over the past 40 years. Really, we didn't start to see, the Condominium Act wasn't even created until 1986. So that's probably where you'll want to start. The Planned Communities Act was later than that. The best advice I can give you is you really need to bite the bullet and hire an attorney to help you with the amendment process of your CC&Rs. We have a great cheat sheet called Amending CC&Rs, 5-step plan that you can find on our website at mulcahylawfirm.com. That would be a really good starting point for you. I think probably the most cost-efficient way to do this would be to have the attorney redline your association's CC&Rs with the changes that have been made in the law over the past, since basically 1986, and then give those changes back to your redline form. And then follow our 5-step plan. It's a bulletproof, surefire way to amend your CC&Rs, and it works. So I hope you'll look at that cheat sheet. Okay, our next question, number 14, from a board member. Are living rules necessary? It seems our communities are a regurgitation of the CC&Rs. Board has worked hard to eliminate petty, outdated, and arbitrary parts of our living rules, but owners seem to confuse them with the CCNRs. So really, it's up to your association. If you want to have rules and regulations for your community, sometimes it's a shorter, easier document for owners to read, and it helps ensure compliance when you just have a one-page set of rules or two-page set of rules. But really, it's up to you as your majority of your board as to how you want to handle having rules. So are they necessary? Not necessarily. We have some clients that don't have rules. We have other clients that have rules, and it's a really helpful tool to get compliance by your owners. Next question, number 15. Can our condo association restrict or prohibit political signs on common area grounds? We are row-style homes with common area front yards where residents have placed signs in the past. Okay, so it would be interesting to know, is the front yard like a limited common area, or is it completely a common area of the association? That would be an important question for me to have the answer to. And I also don't know if you're saying you're a condo association. So typically in a condominium association, you can only put political signs in the areas that you own, possibly limited common elements. But if it's only association common elements, they would not be able to put political signs in that area. So what I would recommend is that you have an attorney take a look at your documents and determine whether this area is common area or a limited common area, and then determine where owners can be placing legally political signs on their property under state law. Next question, number 16 from a board member. How can we change our CCNRs to fund for extraordinary expenses? Will state law ever allow for easier changes to the document? So right now, you have to look at what your specific CCNRs say for the amendment provision to determine what the percentage of owners that you're going to need to have vote yes to amend your CCNRs. There have been bills introduced in the past in the Arizona legislature to lower the amendment requirement in CCNRs, but we haven't seen one pass that would be a bright line rule for all associations. It may come in the future, but right now it's not the law. So you'll want to look to what your association's CCNRs state to determine what percentage you need to amend your CCNRs. And number 17, I have a question from a spouse of a board member. All rental property, it does not matter if it's short-term rental or long-term rental, must be registered with Maricopa County. So I agree with that statement. And that's, you can go to, or any county in the state of Arizona, you can go to the assessor's page, and there's information on how rentals, all rental properties, short-term, long-term, can register with the county. And it's an important revenue source for the county because landlord owners have to pay taxes on each rental. If that is true, this is a question, and I report a neighbor who's been renting their property, but it's not registered with the county, can the property owner find out specifically who turned them in? That probably would be a good question for the county. I don't think that they keep track of who makes complaints on this. I do know they investigate the complaints. It's possible that at public records requests, they might be able to find out that information. So I don't have the answer. The county would know the answer on that, but I'm kind of doubtful that they would keep that information. But I could be wrong. You'll have to ask them. Okay, next question, number 18, from a board member. Our Planned Community Association must hold an election every year for all 5 board members under our CCNRs. We are just out from developer control, and this will be our first member board election. 4 of the 5 plan to run again in 2023. When sending the recruitment nomination letter to all homeowners, is it appropriate to disclose the fact that 4 are rerunning and include their names? A lot of associations do indicate on the ballot. I'm not really sure for the recruitment nomination letter. I suppose you could say that these 4 current board members have expressed an interest in running, and we're soliciting anyone else in the community who wants to run. That's fine. If you want to say something like that and disclose their names, that's fine. Sometimes associations will put on the ballot the names of all the candidates that are running, and they'll indicate who's an incumbent. And so that's fine too. Question 19 from a board member. If fewer owners volunteer to serve on our board of directors, Then the minimum number required by our CCNRs, which is 3, can we operate with less without legal entanglements? So you already have a pretty low number of board members, right? 3. So I don't know. I mean, I wouldn't go down to 1 because that's less than a quorum. You wouldn't be able to do anything. So I guess the question is, can we operate with 2? Because 2 out of 3 is a quorum for your association. You have to check your bylaws to make sure that's a quorum. But if I had to guess, usually the majority of the board is a quorum. Can we operate without legal entanglements? Yes, because you're still a quorum with the 2. But I really would recommend that you try to get 3 because it makes it more difficult. You won't be able to have a meeting if one board member can't show up if you only have 2 board members. And it looks bad. 2 people to be making policy decisions for your entire association. Next question, number 20, is from a manager, community manager. Can a board member be behind on dues and still be on the board, even though the CCNRs for our association do not address this situation? I'd also want to check the bylaws for your association because sometimes bylaws will talk about an owner being delinquent and then not being able to serve on the board. And so, I don't know, maybe we're getting a little technical difficulty. You still can hear me. If you can't hear, make sure you're putting a notice in the group chat on Zoom or on Facebook Live. Be sure to make technical correction. Okay, so can the board member be behind on the dues? Check the CCNRs, check the bylaws. Most association documents, unfortunately, do not address this situation. So from a legal perspective, a board member can't be removed by the board for not being current on their assessments in most associations. Now, sometimes we'll have a situation in an association where we have a board member that doesn't pay. And then what happens is we amend the bylaws to include provisions saying if you're delinquent in the payment of any amounts owed to the association, you cannot serve on the board. Is it bad policy? Does it look bad? Is it a breach of fiduciary duty possibly for a board member to be violating the documents by not paying? I do think so. And I think it's very bad for the community, bad precedent, bad optics. So if you're in that situation, I would recommend to get the association's attorney involved to get that board member to pay or maybe voluntarily resign. Okay, question 20 is from a board member. Can HOAs fine owners for their kids' bad and dangerous behavior at the pool or other common areas? Generally speaking, yes. In most associations, CCNRs, if an owner or their guests or their invitees have caused damage to the common areas, the owner is responsible for that damage, and we can fine the owner for violations of the CCNRs. Now, diving into a pool, climbing on walls, climbing on pool ladders, it really needs to be very clear in the rules that this is a violation. I would give them a warning, of course, before you fine them, and then make sure you follow state law before you fine them by giving notice of the violation and an opportunity to be heard before you levy the fine. Okay, next question is from somebody who is very close to me, a good friend of mine, and also a relative of mine who serves on his board in Arizona. So great to see you here today. And the question is the open forum for homeowners to speak at the open session of a general monthly board meeting required or optional? Generally speaking, it's optional, but I've got a little caveat on that. So remember, under Arizona law, before the board takes formal action on any item, the board is required to give owners who wish to speak the opportunity to contribute and speak. So anytime the board makes a motion and there's a second and the board is discussing an item before voting, the owners have a right to speak and give their input on that particular issue. Now, the owners can exercise that by saying, yeah, I'd like to make a comment on this, or maybe the board can open the floor to the owners and ask if anybody wants to make a comment on this. So if your association decides not to have an open forum in the meeting, I mean, usually the open forum, we call it the homeowners forum, is before the meeting starts, and give owners maybe a minute or two to make comments. If your board decides not to do that, you're definitely going to have to be sure to if any owner wants to talk before the board takes formal action on an item, you're going to want to make sure you give the owners opportunity to do that. Now, what some boards do is they just knock that comment period out in the open forum, and the agenda is very detailed so that owners know what's going to be on the agenda, what's going to be voted on by the board, and the owners can make a comment during the owner forums. The board doesn't have to stop the meeting and ask the owners if they want to contribute before the board meeting. So generally speaking, no, you don't have to have an open forum, but keep in mind if you don't do it before it takes formal action, you have to open the floor for owners to comment. Okay, the next question. We have an owner harassing another owner, and that particular owner, we don't have any proof though. Only the homeowner complained about the harassment. The board has gotten several emails from the harassed owner asking the board to do something. We sent out an email to all homeowners to be kind and neighborly, to have a pleasant place to live. How should we remedy this? Okay, this is kind of a sticky wicket, and here's why. Usually, I would say if you have an owner allegedly harassing another owner, there has to be some proof for the board to take action, right? Like a copy of the email that was sent, or maybe a written report by the homeowner documenting what happened, or a voicemail or video or something showing that there actually has been some bad behavior or harassment. So without that, it makes it complicated for the board. We don't have any evidence. We're taking word from one owner to another owner. That makes it complicated for me to write an opinion letter because I don't have any. And so I guess we have to look at the evidence that's been provided. What we may want to say to the owner that's complaining, just based on the facts that we have here, no proof, complaining. We appreciate you bringing this to our attention. Please provide us with evidence so that we can better evaluate this. Or maybe this is a homeowner to homeowner issue and you need to consider your legal remedies against the owner without any proof. It's really not something that the association can be involved in. I think how you've handled it to date has been perfect. I want to just mention one other thing, that if this owner that's complaining that they're being harassed is a protected class under the Fair Housing Act, and that would be somebody that's handicapped. Handicap is broadly defined under the Fair Housing Act. If they're being allegedly discriminated based upon their race, national origin, families with children, if the harassment is due to one of those fair housing type violations, discrimination based on the person's protected status under the Fair Housing Act, the association may have an affirmative obligation to act. But again, we have to have evidence. And the affirmative obligation to act is we have to do something. We have to send a letter to the person that's allegedly discriminating, to receive a complaint, and to cease and desist, as long as the evidence is legitimate and accurate. So I just want to mention that there may be a time where we do have to act, especially if there's potentially a fair housing discrimination complaint and the reason that the person's being harassed is because they're a protected class under the Fair Housing Act. Okay, next question, number 24. Our board elections are coming up in January, and we have a homeowner that is a bully and has been sent a letter to cease and desist, among other things, over the last 6 years. Can this person run for the board? Generally speaking, yes. Usually the qualification to run for the board is that you have to be a record owner. And so if this person is a record owner and they meet the qualifications of your documents, you can't prohibit this person from running. If the person's elected and they engage in bad behavior, then you will need to get legal counsel involved. You may need to remove this person from the board, and that would have to be done pursuant to state law, which requires a vote of membership, a petition, and a vote of the membership. Okay, next question. Number 25. May a board meet in executive session without a director present if they suspect that the director is leaking information from closed meetings? Is a formal legal intervention necessary? So we talk about this often when we're teaching a class on the duties and responsibilities of board members. And we talk about the 3 duties that are really important when you're serving on your board. And it's the duty of care, the duty to avoid conflicts of interest, and then the duty of confidentiality. So this obviously is a problem if you have a director that is leaking information to third parties a breach of the duty of confidentiality, which is specifically outlined in the Nonprofit Corporation Act, which applies to most associations are nonprofit corporations. 99% of them are. So that statute's going to apply to you. And how do we handle it when we think a director is leaking information? So I think a first line of defense would be for the president to raise the issue at a board meeting. And I think you want to get your legal counsel involved. You can do this during the executive session. I think it's important to have that person there so that we can hear their perspective and that you hear whether they deny it or maybe they need a refresher on the fact that they need to keep confidential information confidential. If they continue to do this, you may want to consider adopting a code of conduct for your board. And you only need a majority of the board to adopt the code of conduct. And that would specifically outline different legal remedies that we have if the board member continues to push confidential information from the executive session meetings. We have a great cheat sheet on, this very topic on the code of conduct for board members. You can find it on our website at mulcahylawfirm.com. So I'd encourage you to take a look at that. Look at your legal counsel in to strategize on how to best handle this. Now, should you have a meeting to talk about this board member and not tell that board member who's leaking information about it? I don't think I would do that because that's wrong. That's, something that all board members should be entitled to get notice of a board meeting. Now, if we're going to be taking legal action against this board member for breaching their duty of confidentiality, I think that board members should be there so we can hear their side. And if the board wants to confidential discussion after that board member is given an opportunity to state their position, legal counsel or the manager can ask that board member to leave while we confidentially discuss it. But I wouldn't go behind that board member's back meeting. I think that's just going to be a big headache for you and it's just not proper. Okay, number 26, if I'm a board member. What are the caveats for amending our CC&Rs to require 95% voter approval to dissolve the condominium? Okay, so I'm familiar with your association and actually your legal counsel. And so what I want to just mention is the way that the new statute is written, and I want you to go back and look at the cheat sheet that we shared with you at the beginning of this presentation that talks about how to terminate a condominium. You dissolve a condominium. That high voter percentage is going to be for new condominiums that are created after that statute went into effect on September 24th. And so what I would recommend is if there's inclination in your association to dissolve your association, you need to first look at what your documents say as first line of defense. And if there is nothing in there on that, then we would look to state law, but you're going to be subject to the old law on this because your association was created before September 24th, 2022. And I believe that percentage is much lower, like 67% to dissolve the association, but your association's documents would be controlling first in this situation. Okay, question number 27, and just to give you a little bit of a read where we are on the questions here, we have 47 questions and now we're up to 60 people on Zoom, which is awesome. So we are moving forward to the next question now. Okay, question is from an architectural committee member. We would like to use email as a supplemental method for official communication with our members. Emails were not an option when our bylaws were written. And it says that written notice of each meeting shall be given by the secretary or person authorized by the board by hand delivering or mailing a copy of each notice. Postage prepaid at least 15 days, but not more than 50 days before such meeting to each member. Do we have to change the bylaws which require a 50% community vote, or can we pass a resolution clarifying notice? Okay, so this is a tricky question because state law actually talks about the notice requirement, and it's a little bit different than what your document states. So state law is not less than 10 days before the meeting, not more than 50 days before the meeting and membership. Notice has to be provided to the membership of special meetings of the membership or the annual meeting, and that can only be done in person, giving the notice in person or by U.S. mail. So trying to go around that by doing an amendment to your bylaws isn't going to work. If you are going to amend your bylaws, what you might want to do is make it consistent with what state law says. So change the 15 days. to 10. Okay, you still can send out an email reminder or a supplemental copy by email, but we still have to follow what state law says. And at some point, that state law will maybe be amended to include email notice being sufficient. Okay, question number 28 from a board member. We are revamping our website so that most of it will be secured. For residents, there will be lots of opportunities for interaction, and we will have our resident directory on a secured portion. Do you have advice on the appropriate privacy policy and terms of use for an HOA? I think a couple things on the resident directory. You want to make sure that people opt in to give their personal information. If they want to have that personal information on your resident directory, that would be some advice that I would have. In terms of what's available to the general public versus what's available to residents, you'll want to look at that issue. Anything maybe like meeting minutes, financials would be on the residents only side, making sure that a resident's account is properly protected so that another owner can get their balance ledger, etc. These are all probably really good questions for whoever's building your website to make sure that you're protecting the privacy of owners and also privacy of the association's business in general. And you may want to run by whatever the final determination is with your technology company who's building your website to make sure from a legal perspective, run it by your legal counsel to make sure that they agree with the decisions that you've made. Next question, number 29. Are cluster mailboxes, and this is from a board member, are cluster mailboxes the homeowner's responsibility for purchasing and repairing? If the United States Postal Service has maintained the purchasing and repairing for the past 30 years, the current postmaster in Goodyear has said that the burden is now the homeowner's responsibility. When 30 of the mailboxes in the cluster were vandalized, can the United States Postal Service just say it's so without any forewarning or any notice in writing? I don't quite know. I have to see your association's documents on this, but when I would ask for clarification at the post office in terms of why did you purchase this for the past 30 years? If I had to guess, probably the developer purchased the mailbox cluster to begin with. And maybe gratuitously at the Postal Service, when there were maintenance issues, they may have fixed it gratuitously. This may be an association responsibility. So I would want to check the association's CC&Rs and take a second look at this to see if it's something the association may be responsible for maintaining. But I would get the background information from the Postal Service. I would also talk to the board about it and look at the prior meeting minutes, maybe even more reach out to the prior developer if they're still around to ask for if they have any background information on this. Next question, number 30. It looks like we have about 18 more questions. And number 30 is, if there is no mention of approving a resolution, action taken without a meeting, and special assessment in the CC&Rs or Articles of Incorporation, can they be added to the bylaws? So I really have never seen in the bylaws something on resolutions, ability to approve a resolution. You certainly can if you want to amend your bylaws to include that. Actions taken without a meeting, that's a sticky wicket because there are 2 administrative law cases in Arizona that say that taking an action without a board meeting, absent or when there isn't an emergency circumstance that would allow the board to take emergency action is potentially a violation of state law, the open meeting law. So I would be really reluctant to advise a client to add a section to your bylaws or your CC&Rs on taking actions as a board without having a meeting. Usually they call that like unanimous written consent. The only time I would add something on that would be to comply with what the open meeting law says, where there's emergency circumstance, we can suspend this requirement, take action. Special assessments, that needs to be in the CC&Rs. That's not something you can put in the bylaws because that's an affirmative obligation to pay. And I would not, if I were helping you with this amendment, I would not advise you to put in the bylaws. It may not be enforceable in the bylaws. That needs to be in the CC&Rs. Next question, 31 from a board member. Can the president alone approve a $5,000 maintenance assessment without the board's knowledge and approval? Or can the board approve the $5,000 estimate by email? So it just depends. Depends on how business is operated at your association. Some associations give authority to the president to make expenditures, put a dollar amount on it, discussed in a board meeting, and it's understood and agreed to in the minutes that this is allowed. Sometimes the manager is given that authority, management contract. I guess without the board's knowledge and approval, that's a problematic thing here. That shouldn't be happening. Now, if it's an emergency and it's the summertime and we can't get a quorum of the board, we can't get any board members to respond, and a tree just fell on the common areas, we need to get a tree removed, I'd probably be okay with the board president paying $5,000 to get that tree out there. Can the board approve an estimate by email? Not advisable unless it's an emergency. Next question, 32, from a board member. A homeowner is demanding pre-lawsuit damages from a common area tree that's mature, dropping blossoms into their pool. The tree previously was trimmed back from the wall. HOA hired a handyman, trespassing on the common area, and proceeded to hack off main limbs back to the trunk before being ordered off. In order to prevent a pending suit, the board is contemplating the removal of the tree and suitable replacement at the HOA expense. Would this create an opening for the HOA to then threaten the same suit for removal of the additional border trees? Okay, so this is a fact-intensive question. It's hard for me to follow what's going on here. But I guess a homeowner wants to be paid because a tree was dropping debris into their pool. I don't really see that being an issue here that I would be advising the board to pay anything on, not based on the facts given me. Looks like, I guess the question is, would this create an opening for the HOA to threaten the same suit for removal of additional bordering trees? I have to look at the facts on this. I don't know if you have trees that are dropping things at others' owners' yards. I don't know if it's causing damage. I don't know if it's causing wall damage. There's a lot of facts here that I don't know. So you're going to have to reach back out to us and send me an email or something with additional facts so I can help you on this. Okay, question 33 from a board member. Regarding the new legislation affecting signage in HOA communities, are no trespassing signs allowed to be placed in individual front yards? An owner has a tree which she took exception to the HOA gardeners maintaining. This concern has been resolved by her contacting her own gardener, an arborist, yet the signage remains and consequently casts a negative ambiance in our small cul-de-sac. So the new HOA legislation that just went into effect September 24th does not address this issue. This is a no trespassing sign. The new legislation deals with political signs pertaining to the association, like association initiatives, such as board elections or CC&Rs, things that the board is actively voting on. The no trespassing sign doesn't fall into that category. What you want to do is look at your CC&Rs and see if no trespassing signs are allowed or are they not allowed. And if they're not allowed, then the board should demand that the owner. But question 34 from a board member. We have recently been told that as a board, we can vote on non-emergency issues by email between meetings and approve items such as architectural and landscape requests, as long as the vote is unanimous. You have stated that only emergency issues can be dealt with between meetings. What is the correct protocol? So I'm conservative in my approach and advice that I give boards. And my conservative advice here to you is that you're violating the law. And here's my facts to back up my opinion. There are 2 cases decided by administrative law judges in Arizona that specifically address this issue in an HOA or condo where actions are be taken outside of a board meeting. And 2 administrative law judges in the past 5 years have said that is a violation of the open meeting law in Arizona, the Condominium Act and the Planned Communities Act. And I think if you go back and reread the Condominium Act, Planned Communities Act, you're going to see the specific language of the Arizona open meeting law. It talks about the fact that it is the intention of this law that all decisions that the board makes need to be done in an open board meeting. So if you're making decisions in between meetings by email or approving items, and trying to fall back on this unanimous written consent that's in the Nonprofit Corporation Act, just recognize there's 2 cases already that say you can't do this. And then look at the law itself, the open meeting law, and it's very clear this can't be done. And the Condominium Act and the Planned Communities Act are more specific than the Nonprofit Corporation Act. And I think they trump the Nonprofit Corporation Act. So my advice to the clients would be, don't do this. You don't want to make a test case in Arizona that this goes up to Court of Appeals or the Supreme Court of Arizona and you lose and spend a bunch of money defending it. Do the right thing. The homeowners have a right to know what's going on and a right to listen in open board meetings when the board's making decisions. The only exception is for emergency issues, and that's right in the Arizona open meeting law. And if you want to deep dive on the open meeting law, we have a great cheat sheet on this topic on open meeting law in Arizona and how to follow it. Go to our website at mulcahylawfirm.com and it gives you a great overview of everything you need to know about the Arizona open meeting law. Okay, next question. When a homeowner, this is from a board member, when a homeowner asks in an open session board meeting why they only have access to the meeting agenda and not the full board packet, what is the appropriate answer? They stated they should have access to the complete packet due to it being an open meeting. Our open packets can sometimes be 80 pages long. So the answer we should give is that under Arizona law, we are only required to have the agenda for you at the board meeting. You are welcome to ask for a copy of the board packet, and anything that is discoverable under the law will be provided to you after the meeting. You can make a request and we can provide a copy of that to you, or if you want to see it after the meeting. There will be some things that will be withheld, like the delinquency report, the violation report, if there's an opinion letter from your attorney. Those type of things will be pulled and not provided to the owner because those can be held under the law. Now, I know that they're not going to be happy with that because they want to be following right along with you during the board meeting, but you're not under any legal requirement to do that. If you want to, certainly can, but that's a lot of paperwork. And I don't know of any associations that are something like that. Question number 36. As homes are going up for sale, a few are behind on assessments and or fines. No one is coming forward to us for disclosure. How do we protect ourselves and get paid or the fine corrected? So if you have owners that are delinquent in the payment of assessments, you should be placing a lien on their property. And that should be done once the assessment is 60 days behind, 90 days behind. Properties for sale, do it the minute they're behind it all. So the title company should pick up that lien. And if they don't, the title company is on the hook for not transferring the property to clear title. The fines are a little bit trickier. So the assessments, the way to handle it is you should pay the property early and then you will be paid when the property is sold. If the fines are a little trickier because under the law, the law says that in order to collect a fine, you have to have a judgment and that judgment is recorded. It becomes a judgment lien. So if you have fines on an owner's account, but you haven't yet gotten that judgment, recorded it to make it a judgment lien, there may be an argument at the close of escrow that basically says that you don't have a judgment against us. Association doesn't have a judgment against the owner, so therefore you can't collect it. And that is a good argument from the owner's perspective. One thing that you might want to do is when a home goes up for sale in your community, what I would recommend is that the board contact the owner and remind them that the owner and the realtor, and remind them that they have a responsibility to contact the association to get a disclosure statement. And the disclosure statement will outline all of the fees that are owed. Also, sometimes maybe the title company doesn't know who to contact. And if you are noticing the same title companies sales, you may want to provide them the association's information. If you're under 50 lots or units in your association, which you may be, the owner is responsible for providing the disclosure statement, not the association. But I think if you contact the realtor and say there are issues that need to be resolved prior to this close of escrow, and you're asking that maybe at the time of the sale that will contact us for a disclosure statement, realtor is going to have a responsibility then to do that. Okay, next question. There used to be 5 board members, and due to some resigning, we ended up with just 2 left of the 5. So you're less than a quorum now. The 2 board members that were last on the board just decided that they would add 1 more member and go to 3. Is this legal? Probably yes. So if you had 5 board members and you had 3 resign, 2 isn't a quorum. But usually there's a provision in the bylaws that says that whoever the remaining directors are, even if it's just 1, they can appoint replacements to the directors' positions that have resigned. So probably that is okay. Even though they've only done 3, maybe they can't bring 5. Just as long as they have quorum, that's sufficient. Of course, you should try to have 5, but sometimes that's just not possible. Okay, next question. The board has seen that a homeowner has started to run a business from his home. Our CCNRs do not allow businesses, and he claims it's just a hobby that generates income via online sales and selling at community events. Is there anything that the board and community manager can do to stop this? We're afraid that other homeowners will want to do the same if we turn a blind eye to this. We are aware that other homeowners operate small businesses that don't generate traffic or have employees. So I think that there's some important follow-up questions that I would need to know. Okay, so this homeowner you're saying started to run a business. Your CCNR is saying no businesses. Apparently, he's just doing online sales and selling at community events. So I'm not hearing that there's employees coming to the property or that there are a lot of trucks delivering inventory, things that would be causing a nuisance to neighbors. The parking is clogged up on the street. There's noise or there's a smell that's emanating because of this. Or there's trucks all day, every day, dropping off merchandise. I guess my question is, you're aware that other owners operate businesses that don't generate traffic and have employees. So I don't know if that means that this one does. I guess I'd have to look at the facts on this. What I will say is that these business prohibition cases are sticky. They're sometimes hard to win because it's not like a chiropractor operating a chiropractic shop out of the garage and you can't really see the business. It may be really difficult for us to enforce this provision against the owner, especially because we're allowing other owners to operate small businesses out of their house. And let's face it, since the pandemic, most of the workforce is now able to work remotely from home. Is that considered operating a business? So I need to know more about this, and I would be very cautious on how you proceed on this. Get your counsel involved for sure. Okay, question number 39, and we have a total of 49 questions. So we're down to our last 10. From a board member, now in effect for condos is that you need a high percentage of members to vote yes to dissolve the condo. What would the percentage be to dissolve a planned community? Okay, so to dissolve a planned community, you're going to look at the documents say for your planned community. The CCNRs typically will outline, and the articles of incorporation will outline what the procedure is. There is no state law for planned communities. Okay, next question is from a board member, number 40. Are there different requirements for what constitutes a majority for different documents and activities, such as a majority of the membership to approve CCNRs, bylaws, rules, and decisions made in a board meeting? So yes, you have to look very specifically at the language in the documents. So like how to have a board meeting. It's a majority board, typically is quorum. So if you have a 5-person board, that would be 3. How to amend the CCNRs. Usually it's a percentage of the total votes in the community. Sometimes you have provision in the documents, look at the language very carefully and have your legal counsel weigh in on this. Sometimes it's just a majority of the eligible voters. Sometimes it's just a majority of a quorum that are required to cast something. So you have to really look at the language and get input from your legal counsel for each decision that your board is making by looking at the association's documents. Okay, next question. Our bylaws from a board member, our bylaws state that directors can be reimbursed for expenses. Our budget is $900,000. Do directors' expenses need to be approved for supplies under $100 at a board meeting? Does the president have the authority to spend on sandwiches for working meetings? Okay, so lots of different questions in this one. So can directors' expenses, can you just get reimbursed for them without being for under $100 without having it disclosed at a board meeting? Probably yes, but there really needs to be a good paper trail in terms of the president needs to submit a receipt for what was purchased, why it was purchased, and then the check to the president should indicate, what it's for, receipt, trace it right back to the receipt number. We do see allegations by owners of misconduct by board members. You may want to have passing mention of this in board meetings. If you do have people that you think are going to challenge it, that would just be a safe way to publicly disclose that this director was reimbursed for this. And it's just a statement and move on. I don't think that you need to vote on it because typically the bylaws will give the authority for the director to be reimbursed for these type of offenses. But if it doesn't have that, they want to talk about that and board vote on it, board meeting. Okay, next question, number 42. Explain why an owner has to occupy their newly purchased investment. So I'm not sure where you're going on this. Sometimes I guess maybe what you're trying to say, I'm not aware of any law. So that's the first thing that says that owners have to occupy property when they buy it. Sometimes CC&Rs will have that provision in there. And if they have that in there, it's enforceable, especially if you bought it or in that provision. Question number 43. Is the board required, and this is from a homeowner, is the board required to approve an updated reserve study, or does it suffice to post it on the association's website? No, there really isn't a protocol for that. The board should vote to hire a reserve specialist to get a new reserve study. And then when the reserve study comes in, they should discuss it in an open board meeting. I love it. If you put it on the website, that's great. Good information for your homeowners. We also have a great cheat sheet that our firm has on reserve funds that you can find on our website or we'll be sharing with you during this presentation today. I would encourage you to do that if you want to take more of a deep dive. Question number 44. Longtime follower, appreciate what you do and love watching your presentations. Often can't join due to time conflict. Excited to see you live. Well, thank you. Thanks for being here. What is your best recommendation for neighbor-to-neighbor disputes? To be specific as it relates to construction projects and vendors, neighbors going on each other's property. At what levels should the association management get involved or should they not at all? So we have a great blog on this topic that we're going to be sharing with you. And we also have the blog on our website. It's called Neighbor-to-Neighbor Disputes, Hatfield versus McCoy's. So if you were tuned in at the beginning of this presentation today, we talked about another neighbor-to-neighbor dispute. And these are tricky because they're facts specific, right? If there's one of the parties that's being discriminated against, it's a neighbor-to-neighbor dispute, and one of the parties thinks that they're being discriminated against and they're protected class and that their housing act, the association may have an affirmative obligation to get involved. And that may just be to write a letter telling everybody that harassment and if there's been proper evidence, your legal counsel should be involved if that's that pattern that we're looking at here. But sometimes it's just petty stuff, right? Hatfield versus McCoy's like, okay, there's a construction project going on lot A, and they're not supposed to have the contractor there on Saturdays. And guess what? Trying to sleep in at Saturday morning, and what do you hear? Bang, 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 bang. The contractor's there on a Saturday. So you jump out of bed in your jammies, go run over to their house, bang on the door, yell and scream, and now we've got a situation, right? Is that something that the association get involved in? Well, maybe if the CC&Rs have a provision that says no Saturday construction, I think it's legitimate for the complaining owner to tell the board, hey, this was going on, and the board can remind the neighbor not to do that. What about neighbors trespassing onto another neighbor's property? This is a tricky situation. Really, you shouldn't be doing that. If the neighbor tells you not to come on their property, do not go on their property. The owner is the one that would enforce it, though. So if somebody's trespassing on property, another neighbor, they should call the police to enforce it. Okay, next question. We're getting down to the end. Question number 45. Our CC&Rs indicate rentals. Our CC&Rs indicate that all lots must be used exclusively for single-family residential use. No gainful occupation, professional trade, or other non-residential use shall be conducted on any lot. Section shall not include the residential leasing or renting of a lot for month to month or longer terms. Our board has been told this wording does not allow the HOA to prohibit short-term rentals of less than 30 days. Do you agree that our current session does not allow us to prohibit rentals less than 30 days? I don't know. I'm looking at this and I think it does not preclude the residential leasing or renting of a lot for month to month or longer terms. It's a weird way to do it because it's not precluding the residential leasing. That's the first part of it. And then it says, or renting of a lot for month to month or longer terms. I think because it says it does not preclude the residential leasing or renting of a lot for month to month or longer terms. I mean, I guess an argument could be made that you can only do months to month or longer terms. It would be so much better if that was clearer. I guess you could send a letter to the owner saying, hey, month to month, define it. And we don't think this is nightly transient rentals. And if somebody challenges it, just recognize the language that are worded. So I think I probably would still enforce it with a letter at least. And if, it's going to go to litigation or we're going to go to the Supreme Court of Arizona, I tell you that I'm not sure you win because month to month is not as clearly defined as I would like it. Minimum 30 days rental would be my preferred language. Next question. Is the board meeting specifically for the board to conduct business, or is it really for homeowners? And does it matter how the board sits at the meeting? Okay, so the board is really to conduct the board business. That's the purpose. The homeowners have a right to attend, listen, and participate. But this is the game time for the board. They're making decisions to run the business of the association. So homeowners are allowed to listen in, but it's really the board taking the action. Does it matter how the board sits at the meeting? I'm laughing about this because I had this situation at my association when I was president. So I'm guessing maybe the board sits at the meeting and maybe they don't look at the homeowners or something, or they have their backs to the homeowners. And that may be annoying to the homeowners. We actually had that at my association where I lived. And when I became president, I asked the board to stop doing that and to face the homeowners because we answered to them. And I got a lot of pushback from the board on that. It's kind of just so ironic to me because it just seemed like a common sense thing to be polite to do that. Now with the pandemic, we're on Zoom most of the time, so I don't have to manage that anymore. But I really do think as legal counsel for the association, we are elected by the members. And for us to be rude and have our backs to the members is not acceptable. So does it matter how the board sits the meeting? From my perspective, yes. Is there a law that says they have to sit a certain way? No. Okay. Number 47 are T-bills, treasury bills, a safe investment for associations. I am not a financial provider. I don't know enough about treasury bills to give a good answer on that. What I would do is talk to a financial advisor, one that's not financially interested and benefit from selling you T-bills and gets advice on that. Question number 48. We have a board member who refused to sign a code of conduct that was adopted by the board. What recourse do we have? I would if they refuse to sign it, we don't need them to sign it because the majority of the board adopted. If they refuse to follow it, that's a different thing. Then get your legal counsel involved to write a letter and potentially think about doing a petition to remove them if the breach of the code of conduct is serious. Question 49, last two questions, because I'm going to go back and revisit that number 8. If a homeowner places an association political sign in the common area, how do we deal with the sign? Does a board member have to remove it? Who can remove the sign? So what I would do is I would just ask the homeowner to remove it within a certain time period. And if the homeowner doesn't do it, then just have the manager or board turn this or something and make sure that they know. No problem. You could put this on your property, but this can't be on common areas. Okay, so I'm going to go back up to number 8. I think there was a statute that I was asked to interpret, and it's a very long statute. And it talks about limits on regulation of vacation rentals and short-term rentals, et cetera, transaction privilege tax. Why don't we have whoever asked me this question? It was a member, and we were talking about does this section override your CC&Rs? I don't have your CC&Rs, so I don't know if this is going to apply to you. What I can tell you is that that transaction privilege tax has to be paid. And so I don't think your CC&Rs would override on any payments in the state. That's probably the most information I can give based on the question. Okay, so we had a great class today. We had 49 questions. We had over 60 people in attendance. So thank you so much for being here today. It's always wonderful to see so many people who care so much about their communities, homeowners, owners, board members, managers, and wanting to know information so that they can make good choices and decisions regarding your association. So appreciate you being here and taking the time. We made it just under the wire. We did it in an hour and a half. It's 1 hour, 29 minutes in, which is awesome. That's always our goal, to finish this in an hour and a half. There is a rebroadcast of this. You can find it right away on our Facebook page as soon as we end this session. So go to the Mulcahy Law Firm Facebook page if you want to listen to something again or you want to share it with your board. We'll also be posting our seminars and other things that we do on our website. So make sure that you check those out as well. I wanted to give you just a quick reminder. I heard a lot of questions today about outdated CC&Rs and what's the procedure. So don't forget to check out our cheat sheet on amending CC&Rs, a 5-step plan. Also, don't forget that we have our free 15-minute review. So if you're in the market to potentially update your CC&Rs, send us your CC&Rs, send it to me at mulcahylawfirm.com, and we'll do a free 15-minute review for you of your CC&Rs and give you suggestions on things that you changed and the percentage that you need to amend your documents. And don't forget, one last reminder, we've got a couple of upcoming seminars in October, virtual seminars that you can join on Zoom or Facebook Live for at least one of them. We have our firm's virtual HOA Condo Academy class coming up on Tuesday, October 18th at 11 a.m. And then we're also teaching a class for the City of Scottsdale and the Neighborhood College on the 20th of October. So go to our webpage to check out when those classes are and sign up for them at mulcahylawfirm.com. Click on the seminars page. And don't forget that our next First Friday live virtual event is going to be Friday, November 4th. And hope you'll join us for that if you have any questions. So we hope to see you again in our upcoming classes later this month. Happy Halloween to everybody. Take care. Thanks for being here today.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.